defending an overdrawn director's loan account in respect of a claim brought against a director by a liquidator. A few things to think about here. Got to remember, what we are talking about is adversarial proceedings. You may have appointed the liquidator, but as soon as they are installed, their job is to realise the assets of the company, and an overdrawn director's loan account is an asset just like any other asset. But when you dispute, as in your capacity as director, when you dispute your liability, that then changes the whole dynamics of the situation, and it becomes effectively an adversarial process, because in order for the liquidator to recover the overdrawn director's loan account, they are going to have to bring legal proceedings if you do not consensually come to an arrangement. And this actually brings about some interesting things for people, because regardless of what I'm about to say next, okay, there are always risks with bringing legal proceedings against anybody. It is never a done deal. There is no such thing as a nailed-on case. There is no such thing as an absolute winner of a case. It simply doesn't exist. And the reason is because human beings are the people that make the decisions, and not every human being, including judges, thinks exactly the same way. Now, what you need to think about is what is going to be required by the liquidator. Now, you will nearly always have some ability to negotiate. That doesn't mean that your negotiations will be successful, but what it should mean in most cases is most people will want to do a deal with you rather than going into legal proceedings, into the uncertain world of the courtroom. And this is something that you need to bear in mind, perhaps, when you're thinking about what your strategy is in dealing with the matter. Be that as it may, if you know that the overdrawn director's loan account is due and you do have the means to pay it, which is a key issue, then it is, generally speaking, makes more sense and less waste of time and less risk in terms of adverse costs if you just simply arrange to repay it. But if it is genuinely disputed, and this is what we're talking about here, then that is when you can consider your strategy. Because ultimately, when there is a dispute, the liquidator is going to have to prove their case. The burden of proof is with the applicant in litigation. The only thing, of course, is in the context of an overdrawn director's loan account, once the liquidator can show that the director has received the money, then the burden flips on to the director to demonstrate that they received that money correctly and that they were entitled to it. So it is a bit of a two-way flip there. But the starting point is the liquidator has to prove that the director received the money, otherwise the liquidator's case is going to struggle to get off the ground. But there are other aspects associated with a director being pursued by a liquidator. When the liquidator goes to pursue an overdrawn director's loan account through the court system, they are going to have to pay legal costs, and the starting point there in particular is they're going to have to pay a court fee, because in most cases, not all, but in most cases, if the liquidator is pursuing a straightforward overdrawn director's loan account as a debt claim, which is what's known as a Part 7 claim, then they will have to pay a pretty hefty court fee, depending on the size of the claim. And that money's got to come from somewhere, and if there's no money in the company, then the liquidator's going to have to find the money to fund it. Now, in this day and age, it's easier because the liquidator can go and approach a litigation funder who may fund the disbursements, such as the court fee. So that's one thing to think about in terms of, and whether or not the liquidator needs to approach a funder will depend on the amount, typically, of the overdrawn director's loan account. It'd be a bit unusual, but not inconceivable, for a liquidator to go and approach a funder for very small sums of money. So the overdrawn director's loan account will, generally speaking, have to be reasonably substantial in order for the liquidator to go and approach a litigation funder. Funders typically want multiples of the money that they lay out. So if they lay out £10,000 in disbursements for the liquidator to pay a court fee and to pay for barristers and things like that, a funder is going to want 2, 3 multiples. So £10,000, they're going to want £30,000 back. I mean, could be different, but that's the general idea. So ultimately, that is one of the reasons why, in context of litigation funding, if a liquidator is pursuing an overdrawn director's loan account, as a general rule, they're not going to get litigation funding unless there's a reasonably sizable claim being brought. But there are funders entering the market these days, and they will fund a liquidator for less and less sums. So there are always potential for exceptions. The next thing to think about is the question of the dispute, because if the matter is genuinely disputed, because the purpose of this video is not to encourage people to dispute for the sake of disputing, because that's completely wrong, and that is just a road to potentially things like adverse costs and even potentially costs on the indemnity basis against the person who's messing about. But if there is a genuine dispute, then it is absolutely crucial that the director puts that dispute clearly to liquidate. And I'm not just talking about writing it down in a few times. It's got to be properly set out, because that ultimately is what the court's going to want to see. So you're going to have to explain why the liquidator's claim, from your perspective as the director, is wrong. And it's not just about you writing a wonderful essay to explain that. You're going to have to produce the evidence from the company's records. The liquidator should give you access to the records if you need them, but you don't forget, this is your own director's loan account, so you should have your own personal records, your own personal bank statements, your own personal credit card statements, etc., to prove your position. You shouldn't really need the company's books and records. You should have your own pay slips, should you have dividend vouchers, should have your own receipts, and so on. You will then need not merely to articulate the position of your defence, but you will then need to cross-reference the points that you make in your defence to the relevant documents. And the more comprehensively you do this, and I'm not talking about putting a witness statement together that is, my witness statement's bigger than yours. It's none of that kind of nonsense. Yes, okay. It's about being able to prove and evidence the points that you make, so that you are not relying on bare assertion. Bare assertion is a total, I can't say it's a total waste of time, but it is bordering on a total waste of time when you are going into the courtroom, particularly when the burden flips over to you and you've received company money and you have to then justify the receipt. You are going to have to do more than simply stand up in court or sit down in the witness box and say, this was absolutely fine. You are going to have to, in most cases, the judges are going to expect you to show why you shouldn't be compelled to repay. So you're going to have to produce the receipts. You're going to have to produce the dividend vouchers. You're going to have to produce the pay slips. You're going to have to produce the rolling accounting working papers to show how your direct loan account evolved over a period of time, over a period of years, okay? And it's also not about just simply dumping a bunch of documents on the back of your witness statement, essay, whatever it is. It's about making a point, cross-referencing it to the proof. Making the next point, cross-referencing it to the proof. So that you present your case in the best possible light, in the best possible light, in the most easily understandable fashion. And what then will happen is the liquidator is going to be advised by a solicitor, typically. And they may also be advised by a barrister who's going to present the case in the court. And if you are in the right, and if your evidence is there, and this is the importance of keeping proper books and records of a company, you will potentially be able to push the liquidator back and enhance your negotiating position. Now, of course, this works both ways, because if your position is that you don't have a strong case, in fact, if your case is threadbare, then the liquidator can do exactly that, but the other way around, to push you back and make you more concerned. Okay, but this is the nature of adversarial proceedings. This is what it's like when you're going to court to prove your case. Bear in mind, the person who is making the decision, the judge, hasn't spent the time that you guys have spent building the case or building the defence. So they have to make a decision based on the evidence in a fairly short space of time. And that's another reason why the information needs to be presented in an easily digestible, proving your case form. Questions, queries, concerns, give us a shout. We know Insolvency inside out.